I'm totally convinced that Africa is the next El Dorado for space, and that the space can be a real driver for development, and will be a key area, a key sector in the future. And to achieve this, I believe that the supervision and the regulation can be a tool. That's what I want to say, and it's completely in line with what Julia said. I think we will share part of this message. So I will see the drivers for the space regulation, and how can space regulation become an opportunity and not just being a regulation and something preventing business. Next slide, please. So next, so start with the drivers of very quickly, because this has already been explained, but I think we should mention that. I think one of the main issues is, of course, as it was said, that to meet the international obligations of states through the treaties, and to flow down this responsibility under local law. So that's probably the main element of space national laws. But there are a few other things that need to be taken into account. It's also the support of the implementation of the countries or even the continents here, space strategy, and how to implement this strategy, this vision that you might have. It's also a way to protect national interest, military, data, national security, as it was explained. It's a way to reinforce the security and the safety of the sector, and I think that's a key element to make sure that the activity, the space activity done in the country, will be done in compliance with the more general and standard safety and security principles. Then it's also ensuring a fair and equal treatment of all actors of the sector. But above all, and I believe this is the key message I want to pass, it's also a tool to foster the development of the national space industry and services, and to encourage foreign investment. And last but not least, it's also a way to strengthen the recognition at international level of the country as a space state. So at the top, you have the UN treaties, and then you have several ways regulation will, of course, there is the national space law that needs to be implemented. And I just want to emphasize at the continental level that, this is something that UNOSA is, repeating and asking countries to develop, to have national space law to flow down the obligations from the treaties. And at the moment, especially in Africa, you have, as it was explained, 19 countries that have launched or will be launching satellites by 2024. And at the moment, we don't have 19 space law regulating these activities. And as it was explained, especially very well explained by Julia, this is key to make sure that the liability of the state can be protected. And I think there is something that needs to be done there to ensure that this is done correctly. But then you have other things like space agency laws that will, of course, take care of all the sector and the activities. And you also have other documents implementing laws, soft laws on very specific issues that was, Earth observation data, telecommunications, etc. And last but not least, the space policies. You have the various types of regulations you have. You have, of course, the national space laws, where you have several elements which should be in there, from authorization and license, and that's key because it's who can do business and how they are regulated. Liability was mentioned. We'll come back to this. This is a key element, and then a few other things like registration, supervision and control, environmental issues, which are key. And apart from this, you have other regulatory aspects which are dealt in different other documents and space agency laws, regulation of data, investment regulation. So it's a broad amount of regulations that need to be looked at to see what is regulating space. It's not just national space law, it's much broader, but all this has an impact on the way the sector is regulated and on the attractiveness of a country. Next slide, please. I think what is important to look at, and that's the message I wanted to pass on, is how this regulation, how you regulate the space sector, can become a tool for the development, for the attractiveness and the competitiveness of a country. The objective, apart from regulating, I mean, the objective is to regulate, make sure it's done, safely, but it's also to attract operators, manufacturers, or investors, not to leave, the business, the space business, to foreigners, just to capture this business. And the legal regime applicable to space activities is a driver for the establishment of space actors. This was mentioned. I can confirm this because I have, as a lawyer, as a partner of Bird and Bird, I receive clients who want to establish their business in the world, and they are asking us to do benchmarking on various aspects to check what is the best place to set up their business. And this is not theory, this is a reality. And there are certain elements that are key for them to do business, and they look at. So if you have the right regulation in place, and if you put the right things in your regulation, that you might attract certain investors, especially because, as it was very nicely explained by Dr. Ouedraogo, now new space, we are in a new environment. It's not just like it was before, where you needed a very heavy investment and a lot of knowledge to go into the space business. Now with new space, you don't need this heavy investment or this huge technology base. You can do business in space with a more modest funding, and it means that any country can develop space activities and can attract investors and space actors. That's key to keep in mind, but it means that the right regulation, or the right regulation needs to be put in place. And I just want to give you one example. It was addressed or mentioned, and I would like to focus on this because I think that's important. It's the liability. It's a key element to understand how it works. Liability, as it was explained, is, on international treaties, the Outer Space Treaty and the Liability Convention, you have various obligations on states, and 30 African states signed or ratified the Outer Space Treaty, and 24 signed or ratified the Liability Convention. Needless to say, the Outer Space Treaty is ratified by 133 states around the world, and is becoming, part of the international law. So these principles of liability that were just explained in the previous presentation by Julia are key. And next slide, please. They need to be inserted in the national law. And the way you do this might, either attract investors or might be an impediment for their investment. Because the idea is that, if you send an object in space, the state will be liable, and there will be a flow down to this entity that sent the object. Now you have two ways of handling this. Either the state says, well, I just don't want to have a liability myself, and I just flow down everything to that entity. But as we know, space is a risky business. So that would mean that especially small ventures might not be able to handle this liability. One other way of doing this, and that's probably a nicer way of doing this, is to say, like some countries are doing, you have an obligation to insure. So you insure your liability. So when you want to launch an object, you need to take an insurance. And so your liability will be limited to the amount of your insurance, which means that you don't have extra liability, and the state will take the extra liability, if any. And this is, for instance, the position that's been taken by several states, United States, United Kingdom, France. And I think this is a nice way of attracting investors, because they know when they come that the liability is capped at the level of their insurance. So they will not incur additional liability. So for operators, it's great because they know that they can do business. Of course, they need to comply with all the rules, the safety rules and the regulations, but they know the liability is capped. And for the investors, it's also interesting to know that in this country, they can invest money and they will not have additional liability. So it's just one example, but it's a good example of how the way the regulation is drafted might be a competitive advantage. So, and I won't come back to old space and new space. I just wanted to talk just 2 minutes about one or two examples. The example of the United States and Luxembourg about space mining. I'm not totally personally in agreement with the content of the legislation and the appropriation of space resources, but it's just an example of how these countries have managed to attract ventures. And if you look at Luxembourg, for instance, I'm always amazed to see that there are several small ventures that are located in Luxembourg because of this new regime that's being put in place. So I'm not saying that this should be duplicated or replicated in Africa. I'm just saying that this idea that a regime that would be favorable to the investors or the private company can attract companies, and this should be really thought of because that can be a real advantage. And I think most African states have the resources on this and they could leverage on this. And even I think that the African Space Agency and the African Union could just coordinate these aspects, not to create a competition between African states, because this would be a nonsense, but to create a global framework that would apply and would be applicable to investors and would help attract them. Thank you for listening, and I'm happy to answer any question you might have.